Have you ever heard of a law that's over 200 years old but could still land you in hot water today? It sounds like something out of a history book, right? But believe it or not, there is a nearly forgotten piece of legislation from the 19th century that's making a shocking comeback and causing major headaches in modern America. This isn't just some quirky old law about not being able to tie your alligator to a fire hydrant. This is a law that's quietly shaping court cases, influencing major decisions, and could even affect your rights without you ever knowing it exists. Today, we're diving deep into the bizarre and fascinating story of this legal ghost from the past. We'll uncover its origins, why it was created, and how it's being used in ways its creators could never have imagined. Stick around, because what you learn might just change the way you see the American legal system forever. So, what is this mysterious law? Let's travel back in time to the early 1800s. America was a young, sprawling nation, and communication was slow. Think horse-drawn carriages and letters that took weeks to cross the country. In this era, a series of laws were passed to deal with problems that seem ancient to us now. One of these was the Comstock Act of 1873, named after its chief proponent, Anthony Comstock, a man on a moral crusade. The law was designed to suppress trade-in and circulation of what he considered obscene literature and articles of immoral use. On the surface, it was about banning lewd materials, but the language was incredibly broad. It banned the mailing of anything related to contraception or abortion information. Essentially, it made it a federal crime to send these items or even information about them through the U.S. Postal Service. At the time, this was a powerful tool for social control, reflecting the Victorian-era values of its supporters. It was a law designed for a world without the internet, without modern medicine, and with a very different understanding of personal freedom and privacy. For most of the 20th century, the Comstock Act faded into the background. A series of landmark Supreme Court cases throughout the 1900s, like Griswold v. Connecticut and Roe v. Wade, established a right to privacy, which included access to contraception and, for a time, abortion. These rulings made the Comstock Act seem like a relic, a piece of legal history that was unenforceable and irrelevant. It was still on the books, technically, but everyone assumed it was a dead letter, a fossilized law that had been superseded by modern jurisprudence. Law schools barely taught it, and most lawyers probably couldn't tell you what it was. It was hidden in plain sight, a sleeping giant in the vast U.S. legal code. But as we all know, things that are sleeping can eventually wake up. That's exactly what started to happen. The resurgence of the Comstock Act began quietly in legal circles. With shifts in the Supreme Court's makeup and a renewed focus on originalist interpretations of the law, some legal scholars and activists saw an opportunity. They started arguing that because the Comstock Act was never officially repealed by Congress, it could still be valid. Their argument is simple. If the court decisions that made it dormant are overturned or reinterpreted, then the original law could spring back to life. This isn't just a theoretical debate happening in ivory towers. It's having real-world consequences. Recently, the law was cited in a major federal court case concerning the mailing of medication used for abortion. The argument was that sending these pills through the mail violates the nearly 150-year-old text of the Comstock Act. Suddenly, a law from the age of steamships was being used to argue about telehealth and modern pharmaceuticals. This has created a massive legal headache. Imagine the chaos. If the Comstock Act were to be strictly enforced today, it could potentially outlaw the mailing of not just abortion pills, but also many forms of contraception, from condoms to birth control pills. Because the law's language is so broad, some interpretations suggest it could even apply to information about these topics. In the digital age, what does mailing even mean? Does it apply to private carriers like FedEx and UPS? Could it be interpreted to cover electronic communications? These are the questions that courts are now being forced to grapple with. It throws a giant wrench into a system that has been operating under a different set of assumptions for decades. Doctors, pharmacists, And millions of Americans who rely on mailed prescriptions for their health care are caught in the crossfire of this historical legal battle. The core of the issue is the clash between a 19th century worldview and 21st century reality. The Comstock Act was written before women had the right to vote, before the invention of penicillin, and long before the internet connected the entire globe. It reflects a moral framework that is vastly different from that of modern America. To apply its text literally today would be to ignore 150 years of social, medical, and technological progress. This is why many legal experts are sounding the alarm. They argue that reviving such an archaic law is not just about turning back the clock on specific rights, but about creating a level of legal uncertainty that could destabilize countless other areas of life. It opens a Pandora's box of other forgotten laws that could be brought back to serve modern political agendas, regardless of how absurd or outdated they are. So, what happens next? The future of the Comstock Act is currently being decided in the courts and in the halls of Congress. There are active legal challenges making their way through the system, and the Supreme Court may ultimately have to weigh in and provide a definitive answer. Will they declare it a historical artifact, incompatible with modern constitutional rights? Or will they breathe new life into it, unleashing a wave of legal challenges and restrictions across the country? There are also legislative efforts underway to finally and officially repeal the law, to take it off the books once and for all, and remove any ambiguity. This situation is a powerful reminder that history is not just in the past. It's a living, breathing thing that continues to shape our present and our future. The laws written by people in top hats and corsets can still reach out and touch our lives in profound and unexpected ways. This isn't just a legal curiosity. It's a story about how society changes and how our laws sometimes struggle to keep up. It's about the tension between the original intent of a law and its modern application. The saga of the Comstock Act is a fascinating case study in American legal history, but it's also a pressing issue with real stakes consequences for millions. It highlights the importance of being aware of the laws that govern us, even the ones that seem to be gathering dust. As citizens, understanding these hidden legal currents is crucial. The fate of this 150-year-old law is a battle for the very definition of modern America. What do you think? Should old laws like this be enforceable today, or should they be confined to the history books? Let me know your thoughts down in the comments. Thanks so much for watching, and if you found this deep dive interesting, be sure to like the video and subscribe for more explorations into the hidden corners of our world. See you next time.